titles in commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walker.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment, per Christian Walters' discretion. Thank you for your understanding.
Welcome, everyone, to this Saturday, September 4th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. I was doing some research and stumbled across probably the biggest bingo other than NTT. So if you have any friends out there that you want to tune in or let them know, I'd get them on a call tonight, because I'm going to rip off the top of the courts and expose how the courts are operating and the mechanism and the procedure and actually what is really going on. So I've been researching and came across this bingo, and this is probably the biggest bingo I've had since the discovery of NTT. And I was going over the definition of, we've talked about it in the past, acknowledgement of the debt. And in the process of NTT, the acknowledgement of the debt is what we need to do, we thought, as to the stopping the running of prescription. And so we need a definition of prescription. What is prescription? Now, Black's Law 8th edition says prescription: the act of establishing authoritative rules. 2, the rule so established. And 3, this is the one: the effect of the lapse of time in creating and destroying right. And 4, the extinction of a title or right by a failure to claim or exercise it over a long period. Now, we always thought that we would have to combat the losing of the right because they're taking away our rights. So we would have to stop the running of the prescription. In the past shows we've talked about, to overcome the running of the prescription was the acknowledgement of debt. If we go to Black's Law 8th edition, acknowledgement of debt. Acknowledgement of debt under Black's 8. Acknowledgement of debt. It says acknowledgement of debt, Black's Law 8th edition. Recognition by a debtor of the existence of a debt. An acknowledgement of debt interrupts of prescription. I'll repeat that again. The acknowledgement of debt interrupts the running of prescription. So by those two definitions, we always thought that we would have to do an acknowledgement of the debt to stop the running of prescription so we could claim our rights again. So we had the right to extinguish the debt or make a payment or merge the titles and act as a payment. So I was looking through Corpus Juris Secundum and trying to find prescription. Prescription does not show up in Corpus Juris Secundum. But as some definitions through Black's Law again, I came around to actually prescription being limitations of action. So you can do some tracking around through the prescriptions on the bottom of the page there, the definitions, and actually prescription is limitations of action.
Christian?
Yeah.
In my volume, this is in Corpus Juris Secundum 72, prescriptions that show up. Would you like me to read it? It's one paragraph.
Yeah, go ahead.
Prescription. In law, prescription is of two kinds. It is either an instrument for the acquisition of property or an instrument of an exemption only from the servitude of judicial process. In the first sense, as relating property, prescription is treated in adverse possession. Number two, in the second sense, as related to the exemptions from the servitude of judicial process, prescription is treated as a limitation of action. Did you catch it? Because for some reason, I think something got blocked off.
Yeah, read it again. I don't think it came through right.
Okay. In law, prescription is of two kinds. It is either an instrument for the acquisition of property or an instrument of the exemption only from the servitude of judicial process. In the first sense, as relating to the acquisition of property, prescription is treated as adverse possession. In the second sense, as relating to exemptions from the servitude of judicial process, prescription is treated as limitations of action. And it goes in section 1B, and then section 2, and then section A, subsection A.
Right, so limitations of action.
Yeah, and judicial process, yes.
Right. Okay, thanks for that.
I'll look for the acknowledgement, and I'm going to mute out until I find it.
Okay. So now we come to limitations of actions in Corpus Juris Secundum, Book 54, CJS. So it goes through scope and title, and Section 2, page 17, talks about at common law, there was no fixed time for the bringing of actions, and there could then be no limit unless it was fixed by. Those limitations are created by statute and derive their authority therefrom. They are legislative and not judicial acts. Section 3, nature and purpose. The statutes of limitations ordinarily are regarded as statutes of repose, which confer no right of action but are available only as defenses. Skipping down, it says, subject to avoidance by the courts under certain circumstances. Page 18, next paragraph. While it's been stated that statutes of limitations defy strict categorization as either substantive or procedural law, right there's your two classifications. There's your equitable side, there's your at-law side, there's your public versus private right there. Repeating again, while it has been stated that statutes of limitations defy strict categorization as either substantive or procedural law, they are generally considered to be procedural. In other words, they're at-law, rather than substantive, or in other words, rather than being equity in nature. So I'm going to read that all again. While it has been stated that statutes of limitations defy strict categorization as either substantive or procedural law, they are generally considered to be procedural rather than substantive in nature. They are available only as defenses and rarely operate against one in the enjoyment of a right. You want to claim rights only, not at-law side. If you claim at-law side, you're hanging yourself. Everything I'm reading in here points to that. Don't be fools and go on the at-law side. Skipping the next down at the last page 19, that section says the expiration of the limitations period creates a right in one party as it extinguishes one in another. Section 4, distinction. Limitations have been discussed from various other matters such as latches, presumptions, and prescription. So prescription is the same as the limitations of action. Continuing on page 20. Limitations are to be distinguished from other matters such as latches. Limitations is not merely a presumption, it is a rule of law, and the statute of limitations is thus to be distinguished from what is known as the presumption of payment arising from lapse of time. Very interesting. What is known as a presumption of payment arising from the lapse of time. Continuing on, according to some writers, the term prescription covers both senses in which the word limitation has been used, that is to say, as conferring a right, and as taking away a remedy merely. On the other hand, the difference between the statute of limitation and the law of prescription has been declared to consist as a general rule in this, that the former takes away a remedy and the latter confers a right, that the former presupposes the existence of a right of action which has become barred by the lapse of time, while the latter denies that the alleged right of action ever existed. Next paragraph. Under some statutory provisions of statute of limitations, that is, prescription, bars the remedy, whereas a preemptive statute totally destroys the previously existing rights so that on the expiration of the statutory period, the cause of action or substantive right no longer exists to be enforced. And unlike statutes of limitations, preemption cannot be interrupted or suspended. Next section, statute of limitations and statutes of repose, distinguished generally. While in case law, repose and limitations were often used interchangeably. Today, distinctions are being made. The judges are being forced to make these critical distinctions by the influx of statutes of repose passed that affect several areas of the law. Accordingly, it has been stated there is a marked difference between a statute of limitation and a statute of repose. A statute of limitation normally governs the time within which legal proceedings must be commenced after the cause of the action accrues. A statute of repose, however, limits the time within which an action may be brought and is not related to the accrual of any cause of action. The injury need not have occurred, much less have been discovered. Unlike an ordinary statute of limitation which begins running upon accrual of the claim, period contained in the statute of repose begins with a specific event occurs regardless of whether the cause of action has accrued or whether the injury has resulted. While a statute of limitation bars the cause of action if not brought within a certain time period, the statute of repose prevents a cause of action from arising after a certain period. Thus, the repose serves as an unyielding and absolute barrier and prevents a plaintiff's right of action even before his cause of action may accrue, which is generally recognized as a point in time when the elements necessary for a legal wrong collate. The bar of a statute of repose is absolute, whereas a bar of statute of limitation is conditional. Next section, statutorily created rights of action. Now, I'd like to know how your statutes and codes create some right. That's a direct violation of the Declaration of Independence, which says that God has given you all the rights. The statutes don't give you rights. Statutorily created rights. The distinction exists between statutes of limitations and special statutory limitations. Special statutory limitations, qualifying a given right in which the time is made in essence of the right created, and the limitation is an inherent part of the statute out of which the right in question arises, so that there is no right of action whatever independent of the limitation. A lapse of statutory period operates, therefore, to extinguish the right altogether. For example, those statutes which create substantive rights unknown to common law, and in which time is made an inherent element of the right so created, are not statutes of limitation in the sense of the merely suspending the remedy and not the right of action. It is possible that a statute characterized as a hybrid statute governing the time to sue in connection with the statutorily created cause of action has two separate and distinct functions. On the one hand, it acts as a statute of repose, dealing with substance and affecting the right, barring the suit before the cause of action even arises, and on the other as a statute of limitation characterized as procedural and affecting the remedy, barring the statute after the cause of action accrues. Turning, I'm going to jump ahead into section 85 under section B, tolling in general, ignorance, fraudulent concealment, duress, and undue influence. Section 85, tolling in general. To toll a statute of limitation means to show facts which remove its bar of the action. To toll a statute of limitation means to show facts which bar of the action. It is generally held that once a statute of limitation begins to run in the absence of express statutory language, courts will not allow the tolling of the statute of limitation, particularly where it is determined that it would not be in consonance with the legislative scheme. On the other hand, the statute of limitations running for which would otherwise bar the cause of action may be tolled when such result is consonant with the legislative scheme, even though the right of action is given by statute, and the courts may apply the doctrine of equitable tolling to accomplish this result, as discussed infra in section 86. The basic question to be answered in determining whether under a given set of facts the statute of limitations should be tolled is one of legislative intent as to whether the right shall be enforceable after the prescribed time, or whether the legislative purposes are effectuated by tolling of the statute of limitations in a given circumstance. In determining the legislative intent, the court will examine the purposes of policies underlying the limitation provision, the law to which it applies, and the remedial scheme developed for the enforcement of the rights given by the law. It may be found that the statute of limitations may be tolled where its policies are outweighed by the interest of justice in vindicating plaintiff's rights. The statute of limitations in most cases has been told not when plaintiff has slept on his rights, but rather when he has been prevented from asserting them. Read that again. The statute of limitation in most cases has been told not when plaintiff has slept on his rights. Now, there's an equitable maxim that says that he who sleeps on his rights has no rights. So, slept on his rights, but rather when he has been prevented from asserting them. Next paragraph. Saving statutes which delineate certain situations with the statute of limitations will be told have been enacted, such as those suspending the operation of the statute for personal disability, as discussed infra section 105 through 120, including coverture in the case of interspousal actions considered infra 111, and personament treated infra section 115, infancy discussed infra on 112 through 114, and we'll skip down a little farther. But the rule may not be applicable where a right of action is created by statute, which also places a limit on the existence of the right. Next section, 86, equitable tolling and related matters. Whereas in conjunction with the legislative scheme, courts will apply the doctrine of equitable tolling of the statute of limitations to avoid technical forfeitures, which would justifiably prevent the trial on the merits. So in order to serve the ends of justice where technical forfeiture would unjustifiably prevent a trial on the merits, the doctrine of equitable tolling may be applied to toll the running of the statute of limitations. Remember, statute of limitations is prescription, provided as in conjunction with the legislative scheme. Among the criteria considered by the courts whether the defendant actively misled plaintiff as his rights, and whether the plaintiff has in some extraordinary way prevented from asserting his rights. So whether the plaintiff was in some extraordinary way his rights, as where an individual has relied to his detriment on the statutory interpretation which subsequently judicially overruled or substantially redefined. The decision whether the doctrine should be applied lies within the discretion of the court. Judicial restrictions on the application of the doctrine of equitable tolling must be scrupulously observed by the courts, although the absence of prejudice to the defendant is a factor to be considered in determining whether the doctrine of equitable tolling should apply once. A factor that might justify such tolling is identified and is not an independent basis for invoking the doctrine and sanctioning deviations from established procedures. I'm going to skip a little section there, subsection. Doctrine of contra non volentum aguere nulla curit prescriptio. Forgive my Latin. The doctrine of contra non volentum aguere nulla curipto prescripto, an exception to the prescription rule, tolls the prescriptive period when the party is unable to exercise his cause of action when it accrues. The doctrine recognizes certain situations in which the prescriptive period is prevented from running, and where there is some legal cause which prevented the courts or their officers from taking cognizance of an act or acting on plaintiff's action, and where there is some condition coupled with the contract or connected with a proceeding that prevents a creditor from suing, where the defendant himself has done some act effectively to prevent plaintiff from availing himself of the cause of action, whereas a cause of action has not manifested itself with sufficient certainty to be susceptible of proof in court of justice, and where a defendant has concealed information or deceptively lulled plaintiff into action. Now, you might want to talk about these things, plaintiff and defendant, and reverse them in your mind, because actually you're not the defendant, you're the plaintiff, but you never come in with an action. Continuing on, or where the cause of action is not known or reasonably knowable by the plaintiff, even though his ignorance is not induced by the defendant. However, the delay in bringing the suit by the plaintiff may not be willful or a result of his own negligence. This latter situation is generally similar to the statutory instances where the prescription does not begin to run until the claimant has knowledge of his cause of action, and under which the cause of action does not mature, so that the prescription does not begin to run until it is known or at least knowable. And the concept that the mere ignorance of the cause of action does not prevent the running of a statute of limitations or a prescription in its modification, that a cause of action does not accrue until claimant knows or should reasonably know to the cause of action as discussed detailed infra section 87. So we could jump over to say 87, where ignorance of cause of action, discovery rule. Generally, mere ignorance of the existence of a cause of action or of the identity of the wrongdoer does not prevent the running of a statute of limitations. However, in particular circumstances, the discovery rule will be applied, under which a cause of action does not accrue until a claimant knows or should reasonably know of the existence of his claim. So generally, Mere ignorance of the existence of a cause of action or the identity of a wrongdoer does not prevent the running of statute of limitations, except where modified by statute. The rule is that the cause of action accrues when the act upon which the legal action is based took place and not when the damage became known. Difficulty in asserting the existence of the cause of action is irrelevant. However, special rules apply in the case of involving particular hardship or other circumstances, justifying different accrual rules. And in these circumstances, the discovery rule is the test to be applied in determining whether the plaintiff's cause of action has accrued. Under the discovery rule, a cause of action does not accrue until a claimant knows or should reasonably know of the existence of his claim. The rule avoids dismissing a suit on grounds of limitation when blamelessly ignorant of the cause of action. Initially, the rule was applied to malpractice actions, but subsequent decisions have gone much further and have acknowledged the relevance of the doctrine whenever equity and justice have seemed to call for its application. The purpose of determining a discovery rule to be applied to statute of limitations based on the logic of the matter. Limitations should not bar a claimant before he has reasonable basis for believing he has a claim. In situations in which the plaintiff is unaware that his legal rights have been infringed, he cannot be said to be sleeping on his rights. That is important. Remember that. The discovery rule is to be applied circumspectively in the case-by-case basis and not applicable to the situation where the plaintiff waits to file suit or a claim until he has some assurance that he will be successful in the merits of his claim. In addition, a plaintiff cannot be permitted to wait until he knows of all the injurious effects on the consequences of the actionable wrong. The rule is an equitable adjustment in and not an abrogation of the statute of limitations, and when the rule pertains, its application must be governed by the usual principles relating to such statutes. In determining whether and how the discovery rule should be applied, the courts must identify, evaluate, and weigh the interests of the opposing parties, balancing the hardship on the plaintiff's caused by the bar of the suit against the burden on the defendant to obtain proof of his defense. So the next section under B, one of diligence. I'll just kind of skip around. One who asserts a cause of action against another has the duty to use all reasonable diligence necessary to inform himself of facts and circumstances upon which the right of discovery is based and to institute the suit within the statutory period. However, there's always these howevers. And a plaintiff need not establish that he exercised due diligence to discover the facts within the limitations period unless he is under a duty to inquire and the circumstances are such that failure to inquire will be negligent. So the statute of limitations will be told only for one who remained ignorant through no fault of his own. So if he fails to investigate when put upon inquiry. So next section, 88, fraudulent concealment. They're not doing fraud upon the court. We are. We're being caused to do the fraud. What they're doing is fraudulent concealment. Fraudulent concealment, a cause of action. As a general rule, fraudulent concealment of a cause of action tolls the statute of limitations till the cause of action is discovered. So you haven't discovered that you've got a cause of action yet. You don't even know it. Or might have been discovered by the exercise of diligence. Fraud or concealment prevents such other from obtaining. As a general rule, when the party against whom a cause of action exists in favor of another by fraud or concealment prevents such other from obtaining knowledge thereof, the statute of limitations is tolled and will commence to run only from the time the cause of action is discovered or might have been discovered by the existence of diligence. Next paragraph. Fraudulent concealment is an affirmative defense to an assertion that the statute of limitation has run. Next paragraph, skipping. The doctrine of fraudulent concealment is a separate concept from the discovery rule applied to statutes of limitations on claims for fraud. Thus, although there is authority to the contrary, fraudulent concealment, which will toll the running of the statute of limitation, does not depend upon the underlying cause of action between inherently fraudulent, but requires independent acts of fraudulent concealment or the events or circumstances continuing the underlying cause of action. While under some authority, application of the doctrine generally does not rely on existence of a fiduciary relationship. It is, nonetheless, especially applicable where there exists between the parties a fiduciary relationship or one of trust. Under other authority, however, it is in fact necessary that the fiduciary relationship exists between the parties in which defendant is under a duty to disclose in order for the fraudulent concealment doctrine to be applied. The concealment which operates to toll the statute of limitations generally must be effectuated by the defendant. Fraudulent concealment tolls the statute of limitations only for as long as the concealment endures. For purposes of tolling the statute of limitations, concealment from a class of individuals is also concealment from each individual member of the class. Next section, inequity or at law. Here's your private versus public. The rule that a fraudulent concealment postpones the operation of the statute of limitations until discovery of the fraud is settled doctrine in courts of equity. In actions at law, a fraudulent concealment generally will postpone the operation of the statute of limitations. Jumping down to 89, section 89, diligence and effect of knowledge. Fraudulent concealment will not toll the statute of limitation if the failure to discover the cause of action is due to the plaintiff's own negligence or lack of diligence, or if the plaintiff in fact has knowledge of the cause of action. And then you could go on what constitutes fraudulent concealment in 9D. I'm going to skip that. I'm going to get into the part that's really going to make the difference. Page 239. Under Book 54, Corpus Juris Secundum, Limitations of Act, Section 184, starting out as a general rule, and this is under Section C, and Section C is entitled Trust. Trust being in a subsection under the Limitations of Action. Page 239, C, Trust. Section 184, the general rule. The statute of limitations will not begin to run in favor of the trustee of a direct, express, and continuing trust until the trust terminates, or there has been a repudiation by the trustee and an assertion of an adverse claim, and that fact made known to the beneficiary. Now, let's go to a definition of repudiation. Repudiation, the esteem in which a person is held by others. Evidence of repudiation may be introduced as proof of character whenever character evidence is admissible. I think I got the wrong, repudiation. Okay, repudiation, wrong definition. A person's refusal to accept a benefice. A party's refusal to accept. 2. A contracting party's word or actions that indicate an intention not to perform the contract in the future. A threatened breach of contract. Remember that. Threatened breach of contract, or it could be a threatened breach of trust. Repudiation, it's a refusal to do the duty, in other words. Really insubordination. It's a breach of trust. Now, let me go over that general rule again. The statute of limitations will not begin to run in favor of the trustee of a direct, express, and continuing trust until the trust terminates, or there has been a repudiation by the trustee and an assertion of an adverse claim, and that fact made known to the beneficiary. Now, picture yourself in court, that this is happening in court. Everybody's seen those 6-block diagrams where one side's private side, the other side is the public side, and it's an expression of the trust, really, because you've got trust parties there. You've got grantor, trustee, and beneficiary on a private side. Then you got the other side. You got trustee, or you got grantor, trustee, and beneficiary on both sides. They have never left the republic. They have caused us to leave the republic and join into the public side. They have duped us into it. We have always been the beneficiary. They've always been the trustee. They've always been responsible for paying the bills. But what they're doing is they're doing a repudiation in court. As trustee, they're repudiating, and they're giving you a bill that they should have paid, and they're going to get an imputed change of your status of being beneficiary. They're going to impute to you the duty of trusteeship. Let me read this paragraph again. The statute of limitations, which will not begin to run in favor of the trustee of a direct or express and continuing trust. So we have an express trust here, although we don't have an existence of a trust until you express it, so no trust really exists. Although they know it to be a trust, and they know they're a trustee on the trust. But they don't want to do the duty on the trust, so they repudiate. They willfully say they're not going to do the duty. So it's an expressed and continuing trust until the trust terminates, or there has been a repudiation by the trustee. So they repudiate because they're the trustee. There has been a repudiation by the trustee and an assertion of an adverse claim. They gave you a bill. That was the assertion of the claim. They gave you a charge or an indictment, or they gave you a bill in the mail. That was the assertion of the adverse claim. They gave you notice. Continue on. And that fact made known to the beneficiary. They've made that fact known in open court or by sending you a bill in the mailbox. You've had knowledge, and you're not doing your due diligence because you didn't know what the game was. So now we get into the body here. It says, in the general rule discussed in Supra 21, that in a case of a direct express and a continuing trust, the statute of limitations does not run between the trustee and the beneficiary as long as the trust subsists. Thus, the statute of limitations will not begin to run in favor of the trustee until the trust terminates, as by its own limitation or by the settlement of the parties. They're doing a settlement in court on you by repudiating. Settlement of the parties, continuing on, or until there has been a repudiation of the trust by the trustee and an assertion of an adverse claim by him, and that fact made known to the beneficiary, or at least until the owner of the property has knowledge of the trustee's intention to repudiate the trust. Next section, 185, particular trust within rule. Particular trust. As a general rule, the only class of trust not affected by the statute of limitation is composed of those technical and continuing trusts which are not cognizable at law, but which fall within the proper, peculiar, and exclusive jurisdiction of courts of equity. That's private trust. Continuing on, in determining what trusts are exempt from the statutes of limitations until there's been a termination or a repudiation, in accordance with the general rule stated under Supra 184, the term trust is not to be given its general or popular meaning, but must be construed according to its technical signification so long as not to include anything but actual trust, subject to certain qualifications and exceptions, as in the case of resulting trust and certain constructives or implied trust, considered infra on 186. The general rule applies only to those trusts which have been variously described as express or direct, but you never expressed a trust. So one doesn't exist in the public side, although it exists in the private. Moreover, it is not even every case of a direct and express trust arising between trustee and beneficiary that is exempt from the operation of statute. The only class of trust not affected by the statute is composed of those technical and continuing trusts which are not cognizable at law, but which fall within the proper, particular, or peculiar and exclusive jurisdiction of courts of equity. Therefore, whenever there is an adequate concurrent remedy at law, the statute will apply, although the relief is sought in equity. I'm going to read it again. Therefore, whenever there is an adequate concurrent remedy at law, the statute will apply, although relief is sought in equity, and the statute will run from time of the cause of action first accrued. While no particular form of words is necessary for the creation of an express trust, which will be exempt from the statute, the purposes of the trust, its subject matter, and the beneficiaries must clearly be defined, whether the trust involves real or personal property, and the fact that the instrument evidencing the obligation of the controversy merely purports to create a trust is immaterial. I'm going to skip the fiduciary relationship because you got a trust relationship. 186 is the implied or constructed trust and result. Skip that. 187 is the particular or relationship. Now, this is the debtor-creditor relationship.
CW?
Transaction or relationship. How do you get them?
Yeah, could you repeat that last bit? You said that basically, from what I just heard, we don't have to show proof of a trust? That last sentence. Sorry to interrupt. I'm out.
Okay, that was whether the trust involves real or personal property and the fact that the instrument evidencing the obligation in controversy merely purports to create a trust is immaterial. No, it doesn't mean that. It's just that the evidence of the instrument that creates the trust. Let me start the paragraph. While no particular form of words is necessary to create express trust, which will be exempt from the statute, the purposes of the trust, its subject matter, and the beneficiaries must be clearly defined. So they're telling you that that's got to be in there. But it says that the instrument evidencing the obligation to create the trust is immaterial. Okay, 187, the particular transaction or relationship. And now this particular transaction or relationship, is the debtor-creditor talked about. So the applicability of the general rule exempting trust from the operation of statutes and limitations until termination or repudiation of the trust has been determined with respect to various transactions and relationships such as debtor and creditor, partners, vendor and purchaser, and others. The applicability of the general rule discussed in 184 supra that trusts are exempt from the operation of statutes and limitations until the trust has been terminated or repudiated has been determined with respect to the particular transaction or relationships such as debtor and creditor, and with respect to various other transactions or relationships. Now I'm going to skip a section and go down to the government. It says money regularly paid to a public treasury or coming into the hands of a municipal corporation or public office to be held, paid over, invested according to law has generally been deemed to be held in trust within the rule exempting express trust from the operation of the statute of limitations until termination or repudiation of the trust. The rule is to the contrary, however, if the trust is not expressed. Let me read that again. The rule to the contrary, however, is if the trust is not expressed or arises ex maleficio, or the party entitled to the money can maintain an ordinary action at law to recover it. A county made a trustee by the Constitution is subject to the general rule applicable to other express trusts, and limitations will not run in its favor until after repudiation of the trust and notice thereof brought home to the beneficiary. Next section, guardian and ward. Guardian and ward, under limitations of actions here. Guardian and ward. With respect to the statute of limitations, the relationship between guardian and ward is an express trust, and the statute of limitation does not run against a ward as long as the trust is acknowledged, or until the guardian accounts and is discharged, or repudiates the trust. In order to set the statute in motion, it must be some express declaration or act by the guardian adverse to the right of the ward. Even if a trust exists after final settlement by the guardian, who used his ward's funds in paying for land, it is a resulting trust of law and a mature claim for the purpose of applying the statute of limitations when the amount is finally and fully ascertained. The express trust imposed on the guardian of a mentally incompetent person terminates on his death, so as the limitations then begin to run against the right of distributees to call for an account. Under executors and administrators now, skipping into the paragraph, says here, and that between the personal representative and the creditors of an estate, no trust exists of that kind which is within the exclusive control of equity, and to which the statute of limitations cannot be pleaded. All right, I'm going to skip 188, which is third parties. And now we're getting into the real bingo. 189. Termination and repudiation of trust. And remember, repudiation is putting off of the beneficiary's position as a right into trustee duty as a new trustee. You're being forced into it. So where a trust is fully terminated, as by its own limitations, or by settlement, now this is what they're doing to you, or by settlement, or by other act understood to be discharge of the trust, what they're doing to you right in court, the statute of limitations then begins to run in the trustee's favor. Also, if the trustee openly repudiates the trust, and he does that in open court, and asserts an adverse claim, because he hands you a bill or charge or indictment, and asserts an adverse claim to the trust property with the knowledge of the beneficiary, because you're standing right there in court as the beneficiary, the statute of limitations then begins to run in the trustee's favor. So under the general rule, considered Supra 184, that trusts are not within the statute of limitations until there's been a termination or repudiation where a trust is fully terminated either by its own limitations or by settlement with the beneficiary. Now that would be you're standing in court for the trustee as the new trustee now, or continuing on by some act of the trustee intended and understood by both parties to be in discharge of the trust. In other words, he's discharging the trust duty because he's refusing to do it, and he's giving you the bill to pay, and you're sitting there dumbfounded, not knowing what's really going on, and now you've been switched from being the beneficiary into being the trustee. The statute of limitations then begins to run in the trustee's favor. However, the relation between the parties must be so completely served as to indicate that the beneficiary is no longer controlled by the trustee's influence which prevailed during the existence of the trust. In accordance with the general rule, the trusts are exempt from the statutes of limitations until there has been a termination or repudiation. It is generally accepted doctrine applying to all express trusts that the statute begins to run in the trustee's favor at the time that the trustee openly repudiates, that's in court, the trust and asserts claim, that's he's handing you the charge of the bill, to the trust property coupled with the knowledge of these facts by the beneficiary. Now, that could have been a summons in court or delivered by the sheriff or whatever, but you've had notice. Continuing on. Or, as of the time that the constructive notice, that's the charge of the indictment, of the violation of duty, that's the old trustee, he violated the duty, breach of trust, now may be to the beneficiary, such at the time at which the beneficiary's duty of inquiry arises. This is the bingo, bingo, bingo. Let me read it again. Or as of the time that the constructive notice of the violation of duty may be imputed to the beneficiary, such as the time at which the beneficiary's duty of inquiry arises. When they hand that indictment into your hands and they ask you, do you understand? What they're really asking you is, do you repudiate this repudiation? And then you go silent and hang on to the bill, and you become the trustee. The doctrine has been held to apply even though the trust is a resulting one, and even in favor of persons who become trustees by construction of law. And in case of a voluntary constructive trust, you are volunteering for this. Accordingly, where the existence of a constructive trust is alleged on the basis of a voluntary transfer, that's what's happening, and a subsequent wrongful retention of particular property, the applicable statute of limitation commences to run from the date of the wrongful detention of the property rather than from the date of the transfer. Read that again. The statute of limitation commences to run from the date of the wrongful detention of the property rather from the date of its transfer. The date of the transfer is in court or when you got it, but that doesn't start it. It's when they wrongful detention, where there are repeated acts of repudiation. Repeated acts of repudiation? Huh. Where there are repeated acts of repudiation, the statute of limitations begins to run from the first of them. But in an action involving various income distributions, isn't that what they're doing? You're supposed to be, the trustee's supposed to be paying the bills, the income distributions? But in an action involving various income distributions, an applicable statute of limitation may begin to run as to each distribution when the beneficiary's right to receive a particular payment is repudiated. As to each distribution, when the beneficiary's right to receive a particular payment is repudiated. Your bill was supposed to be paid, but the trustee repudiated it. He refused to pay it. And you didn't bring a cause of action against him. And if you did, you probably would have got put down because you never expressed a trust first. They don't ever claim a trust. Neither do you. But this is what's going on in court. Skip the one about the death. Skip the one about resignation. Now, demand and refusal. In the cases of trust within the rule governing direct or express, remember you got to express trust, and a continuing trust, a demand by the beneficiary that the trustee account or turn over the trust property, and the trustee's unqualified refusal to do so will set the statute in motion. And where there are repeated demands and refusals, the statute begins to run from the first of them. The rule does not apply where a refusal is not absolute but qualified, or where the refusal does not constitute a denial of plaintiff's right and title to the trust fund. Skip the next paragraph. Apart from express trust, it has been held that where a fiduciary relation exists, as in a trust, between the parties, with respect to money due by one another, the statute of limitations does not begin to run until there has been a demand and a refusal. Now, I would say that this is the same as in a trust also. Section 190, character and circumstances of repudiation. Character and circumstances of repudiation. Generally, in order to set the statute of limitations in motion, the trustee's repudiation and adverse claim must be clear, open, and unequivocal. Man, they do it right in front of court. It is clear, it is open, and it is unequivocal. But you're not getting the picture. Continuing on. In order to set the statute of limitations in motion within the rule discussed in Supra 189, the trustee repudiates an adverse claim, whether by acts or words, since repudiation may be proved by circumstances, must be clear, open, and unequivocal, and must be so clearly and fully made known to the beneficiary as to make it incumbent on him to assert his equitable rights. He just never knew to bring it forward. Continuing on, accordingly, in order to constitute a repudiation, there must be something said or done by the trustee in open contravention of the terms of the trust, and of such character that the relations of the parties will become and continue hostile. In other words, the trustee's refusal to pay in court when he gives you the bill, the charge, the indictment, and imputes it to you. On the other hand, continuing on, there need be no formal renunciation of the trust if the acts of the trustee are equivalent to a repudiation and the beneficiary has knowledge thereof. And a sale by a trustee for his own interest, or of a trust fund by the trustee for his own benefit, or in any way clearly inconsistent with the trust and conclusively evidencing a repudiation, is sufficient. However, in particular circumstances, an applicable statute or limitations may not begin to run in favor of the trustee upon the latter's failure to perform trust duties, such as a failure to disperse income, or to render an accounting, or to respond to repeated inquiries. Moreover, it has been held that a mere breach of trust will not give currency to the statute unless the beneficiary elects to consider the trust at an end and to treat the trustee as a wrongdoer. But it has also been held that the rule exempting an express subsisting trust from the operation of the statute ceases to apply where the trust has been openly violated and the suit is brought to obtain redress for the injury resulting from the breach. But you never do that. So you give currency to the statute. You create the currency. Number 191, section, notice. The trustee's repudiation of the trust and his assertion of an adverse will not start the statute of limitation in motion unless and until knowledge or notice thereof is brought home to the beneficiary. A trustee's repudiation of the express trust or a trust subject to the rule governing express trust and his assertion of an adverse interest will not be sufficient to start a statute of limitations in motion unless knowledge or notice of repudiation and claim is brought home to the beneficiary. Right in open court there, giving it to you. And the statute begins to run when and only when the beneficiary acquires the knowledge or receives the notice. It has been held that the rule applies to a bill to establish and enforce a resulting trust. And the rule has also been applied in an action to require an execution of warranty deed to property held in a constructive trust. Next section, sufficiency of notice or knowledge. Actual notice of repudiation of a trust to the beneficiary is necessary, and constructive notice cannot be sufficient. However, there is some authority to the contrary, so that even if the beneficiary does not have notice of a specific repudiation of the trust, it is sufficient if he knows facts from which a reasonable man would be put on notice that the trust has been or is about to be repudiated. While fit, it has been held that the recording of a wrongful conveyance constitutes sufficient notice to the beneficiary, and that the facts done in public office, often to the inspection of all, are noticed to all who may be interested. It is also to be held that the fact that the instruments affecting the repudiation of the trust are recorded, or that the acts of public officers or matters of public record do not constitute sufficient notice to the beneficiary. Next section is section D, but this is the end of the trust, which you could enter into fraud and mistake, and fraud and mistake is where fraud and mistake live in the second division under equity. First division is where trust live. Second division is fraud and mistake. But this ends the trust section. Now let me read the footnote here where it says protracted failure to fulfill fiduciary responsibilities. Now this is under the fraud and mistake section, where it says in equity, under the various statutes, the statute of limitations in cases of fraud ordinarily runs from the time when the fraud is or should be discovered. And it says, see the research notes, the tolling of the statute of limitations by fraudulent concealment of a cause of action is discussed supra in section 88. And under the note, protracted failure to fulfill fiduciary responsibilities, breach of trust, action against government was barred by statute of limitations where theory of recovery was based upon damage suffered because the government's mishandling of a trust responsibility in connection with land awarded to Indian, who was considered ward of federal government's gross and protracted failure to fulfill its fiduciary responsibilities in protecting ward's land constituted implicit repudiation of trust relationship. Did boy say that one again? So, in equity, remember, the action must nevertheless be brought within certain time after the discovery, or even after perpetration of the fraud, or the making of the contract induced thereby. Or the making of the contract induced thereby. That's the debtor-creditor contract that are inducing you to come over and play in the public side when all along you didn't have to. But you jumped in and you played the game. It's all your fault, people. You just never knew. Scriptures say in Hosea 4:6 that I'm perishing for a lack of knowledge. I'm perishing for a lack of knowledge. You need the knowledge. You really can't blame them. You got to blame yourself. The scriptures never says to blame. That's the deprivation of man. When he blamed Adam and Eve, blamed God, blamed each other, blamed the devil, rather than accepting responsibility upon themselves that he did the wrong. Accept the responsibility. Don't blame it on somebody else. It's not their fault. It's yours. I hate to blow everybody's bubble, but you guys are wrong. This immoral attitude of running from the responsibility of paying the debt is absolutely unscriptural. And anybody out there that's doing some kind of methodology of running from the obligation because you're saying that it's a mistake is nowhere, any place in the Bible. You're being repudiated in court or somewhere close by. You got notice and you just never knew. You're perishing for lack of knowledge. Now, I just gave you the knowledge. So that concludes my dissertation for tonight. So let's go to the Q&A and open it up for some questions.
Christian, I got a question.
Hang on just a minute.
Q&A session started.
Okay, I'm back.
Okay. Can you hear me?
Yes, I can hear you.
Okay, so Darren. It was interesting that you said that, but even actually in biblical terms, what they used to do, they used to bring the dispute before the king, and then the king would render the decision. But technically, though, as you said before, isn't this a fraudulent concealment by the court itself, or is that because they basically set up the process the way it is, the at law and the equity side, and basically there's something I know there's a finding of it that says basically you can't conceal it. It's not like, well, find it if you can kind of thing. That was in an evidence case. I can't remember it exactly, but
well, it's interesting to see that right after that trust section, they come in with the fraud and the mistake. This book, or all these books, are laid out in a particular order in such a way. And you should have been probably coming in with, say, the breach of trust or fraudulent concealment. Because really, by the debtor-creditor contracts that you're being duped into going into, that is the fraudulent concealment. and you're being kept from the knowledge of the fact that it's a trust.
Now, is that by the courts or by another party? Who would you say is the main?
All of them. All of them.
Especially the judges, because the judges know what's going on.
They're all culpable for that, I believe.
But okay. Could you just? Okay, I'm sorry. Could you briefly outline the main sections that you were talking about tonight? Because the thing is, at times because I can tell when you get excited when you find something, you talk quicker. And can you just kind of like highlight some of these sections so that in our own spare time we can go back and do the research and read those specific sections that you were referring to just recently in the last like 15 minutes? Because I know, let's see, I wrote down as quick as I could. I had page 17, book 54, CJS, of course, Black Law's 8th. Does it matter? Do you always want to use the most current the current version of Black Laws? Because I know even in Black's 4th, the one thing about Black's 4th, it is like the annotated version and also having case law, but yet again, too, that's the at-law side.
Yeah, well, I like using a more modern day Black's and comparing it to an earlier one, say like around 33 or before, and then maybe one in between. If I really enough time, I would do 3 of them. Yeah, because there was the one gentleman that recorded, Dr. Frederick Graves, and he used Black's 2nd under the definition of equity, what it was. Yeah. Which I found out to be quite interesting. But once again, can you just kind of like give a quick summary on the sections that you read from tonight that is really the key points that you are referring to, so we can actually go back to that? Well, the real bingo comes in under the trust section of the limitations of action, and that was starting on section 184. That's section C under trust. Section 184. B4. And then leading up into it is, but then the bingo comes in 189. Okay, 184, 189. And this is in CJS? Yeah, CJS, book 54, limitations of action. Book 54. Okay, very good. Okay. Anything else that we should focus on? Well, the whole section to the end, which is it ends on 191. That ends the trust section. Okay, so you're saying section 184 and then jump over to 189 through 191. No, starting at 184 through 191 is the trust section. Right. Okay. So leading up and starting at 181, leading up into 189, and 189, that's where the bingo is. Okay. 189, 90, 191, those last 3. Because that's the 189, that's termination and repudiation of the trust. And 190, that's character and circumstances of the repudiation. And 191, that's notice. Now, after that's happened, those 3 things have happened, then it comes into the next section, which is not the trust, but it's under equity, though, because that's fraud and mistake. That starts in 192. And that's where it talked about, or the making of the contract induced thereby. And that's the DC contract. That was the fraud of the fraudulent concealment. The debtor-creditor contract is actually the fraudulent concealment of the fact that it's a trust, because you're being led in to do the debtor-creditor contract. That's so from my understanding is the statute of limitation really is not applicable, especially when we're going not under trust. Not under trust. Right. Statute of limitation or prescription does not apply under an equitable private trust. So there is no statute of limitation. It's only when you bring the action in. Yes, and that ties in exactly what the Declaration of Independence says, that you always have the right. Right, always. Right, because they're unalienable. We can't lose them. Yes. Or surrender them. You're only being caught in a suspension of your rights. You never lose your rights. You always have your rights. Your rights are being suspended. You don't know that you have them. You're the problem. Right, you're waiving your own right, basically. Yes. It's in suspension. It's not like you lost it. You always have it. You just have been duped into believing it's no longer there. But it is. Oh, yes. Bring it forward.
I had another question. I was talking to a gentleman today. We were talking on the thing, and he lost his home. He's trying to get it back. He's in the appeal side, but I don't think he filed his brief timely. And I said, well, what you could do, because he said the reason why he couldn't. I said, well, really, all you could do is why don't you file an affidavit in there and ask them to reconsider? Maybe they will extension, because it's in the state appeals court. I said, well, if anything, you can always even appeal to the federal if you want, but that's at an at-law action. Now, my question is even though that's at law, does he have to create a new separate action to bring that into equity? Does it still affect that, or does he bring the equity remedy even in the at-law action?
Yeah, I hadn't had enough time to digest this, what I just found out last night, so I don't know how this is going to apply to what we have already. But going by what we have already, yeah, he would have to come in and somehow get into equity from the at-law side by coming into the
But can he do that? Because they're separate borders. So I guess my question is can he come in because he didn't come in equity from the beginning and saying, well, I don't consent to a at-law proceeding, because he did once the proceeding stopped and he didn't object. He did consent.
Yeah, but he really didn't know. Now, if you go by what I was reading earlier tonight, leading up into the trust section there, where it's talking about the evidence and knowing it applies when you know. So it comes down to when did you have knowledge that there was a breach or something wrong that say that it wasn't an at-law case at all, it was an equitable one.
Now that comes back in under just like even newly discovered evidence. It's not when the fraud happened, it's when you recognized it.
Yes, right. And then if it comes in fraud, it can never be waived, never can be limited, never can be prescribed.
Right. Now, what he was saying, what he was saying, of course, you want to do it with the bank president or whoever, but the thing was, all the possessions in his home were sold to another guy, and he was thinking that other guy should be brought in the action. My feelings was, I thought he should bring the sheriff in it, because basically the sheriff was serving as a co-trustee, and he sold the trust res to this third party. Or should all three of them be brought in?
Did they have notice that there was, in other words, did the purchaser take for value free and clear of a notice?
All I know is that the home was sold, it was lost in a foreclosure, and the thing is, he didn't get his personal property from within the home, and the sheriff basically sold it to another person.
Maybe the sheriff didn't know because he didn't give the sheriff notice of an adverse claim, and then it was sold to the guy who bought it, and he didn't have notice of the adverse claim because he never brought the adverse claim in or noticed anybody.
Right, there is none right now. Up to this point, There is no adverse claim.
Okay, so there was no notice.
But when he does, the question is who does he really bring in?
Well, he can name those parties, but I think a court of equity will probably let those people slide because they didn't have notice. But that doesn't mean he can't get the damages for the value of the property, say.
Right, exactly.
They sure can't get the performance. So that would be one of those unique situations where equity can't give you a relief. Now it must give you the remedy.
Right. Now, here was another question, and I think we talked about this before.
Let's go back a minute.
Okay.
Let's go back to, it comes back to the relation, because that's what it was saying was key. The relation is key. And It said that if it's a trust, that's the particular relation, the different circumstance. And that's what's key to the whole thing. He's got to express a trust. He's got to express a different relationship from general.
Right, exactly. Right. He's got to claim it. Right.
He's got to do a withdrawal and a redeposit, a special, and claim a new relation.
Right, and from what I understand, he's got everything ready to go, including the indenture. But I guess the way I was looking at it myself is what parties are actually involved in it, because I didn't think that even the gentleman that received the trust res as the furniture really had a party. Didn't really have a part to it, other than receiving a proceed, the trust res by the sheriff, which I think who would be named as a co-trustee in the matter. Besides the bank
he was being
president.
exactly what I explained was happening in the court proceeding. There was a repudiation of the trustee because he refused to make the payment gave you the bill in open court and repudiated it in open court, and now you were imputed as, instead of the beneficiary, you were changed into the trustee, and you got hung for the whole bill, but you didn't say anything at that point. And then there's where you should have come in with a breach of trust and refused the repudiation from the trustee and got the trustee breach of trust, but you never did that. So now the court's under the operational law, under the debtor-creditor thing, under the breach of the trust, because you're now the trustee, sold the property. But it comes back down to where the court was the one who was doing the wrong thing.
Right. Understand. Okay.
How could the court do otherwise than what you would have brought forward and told them? But see, you can always go back because you never knew, and if you didn't know, you can always go back.
Now, how would that basically that claim of didn't know at the time, would that be done, say, affidavit?
Well, just like when Marshall gave the reading on that book that he found about how to put an equitable pleading together.
Oh, okay, right. It would be in the pleading then.
Yeah.
Right. Because I'm always thinking affidavit, because that's still, an affidavit does stand as prima facie as a fact unless rebutted by a contrary affidavit. Because then there can't be any determination because you have conflicting affidavits of fact, or alleged facts anyway. Then it has to be done by the record itself that has been established. But here's just one other thing, because I've been trying to kick this around, and like you were saying before, because we know that the at-law side is let's say if you're suing for monetary relief, but from what you've been saying is that the relief comes on the equity side, but in order to be made whole, and if you can't be made whole even on the equity side, then it reverts back to the at-law side. Now, can you stipulate saying, well, this is the amount that will make me whole again? Can you do that? Or is that a determination that's made by the court or by a jury, or how would that be determined?
I'm not sure whether I would want to traverse the law side of my pleading and actually put a value that I want, because that would be the same as asking for an at-law remedy. And I don't think I'd want to do that. So in my release section, I would probably put it in there that I want a mandatory injunction for the performance, and probably a receiver appointed and resulting trust to be, or constructive trust to be placed over the trustee's assets and tracing of the funds. Or maybe in the alternative, then give me a remedy at law. So I'd do a general claiming of the at law remedy, but not specifically claim something like damages.
Oh, like a dollar amount.
Yeah. Let the court decide that if they can't give me the performance. I'm going to stick to the performance.
Okay, and what if they let's say they don't give you an amount that you feel has been fair and just? Can you still dispute it at that time?
I imagine we'd come back with a second complaint for that.
Can you define that a little bit more so I have a better understanding?
A new independent action. A new case saying that, hey, I got shortchanged here.
Well, let's say for an example, let me just use an example. Let's say it's a foreclosure action. Now what you're doing, let's say it's been passed, it's been years and whatever, but now you're coming in with an adverse action and you're going into equity and you're getting the relief, you're extinguishing the debt, and you're getting all the intricacies of the note and everything that's produced and the bonds and the whole 9 yards. And you're also
in equity.
I'm sorry?
Time has to do in equity.
I'm sorry, you cut out. You broke up a second.
Time has nothing to do in equity.
No, I know, but that was just what you said. But what I'm thinking was that when you're going in, and then now you're coming in a new action because you're bringing it into equity, or are you still going back in that same old action before in equity? In other words, are you creating a new suit, or are you still in that same suit but coming in equity?
Well, maybe I could come in with that motion to reconsider because I don't feel it's adequate and just. There could be two options.
And is that what you would, like you were claiming like you were saying tonight, I just found out, basically, you're saying? Could you do that in a reconsideration?
Yeah, to come back and get a new case based on the original fraudulent concealment.
Okay, so then it is a new action. It's not with the same case number as before. It's a new action, new case number. So it's a whole new separate dealing, correct?
Yeah, depending on how, if it's been longer than 30 days, you're probably going to have to come in with a new action and sue the case.
Right, and that was my point. So let's say, for an example, you're seeking the remedy in equity on that side, okay?
Yeah, win in equity first. Claim the general remedy only if I don't get a release. Not specifically. Don't claim a specific remedy.
Oh, okay. So then let's say right. I know what you're saying. You're not naming anything specific.
Yeah, so I don't win in equity. I don't get what I want as a remedy, and I can come back and dispute that I didn't get what I think is fair.
Okay. And in what mannerism would you do that? In what form? I guess.
Immediately. So I claim, hey, this was an equitable proceeding, and I don't think it was fair and just. And I'm within the 30 days, I would claim for a motion to reconsider, and then come in with the show cause why. Or if it goes past, I could probably come back in with another independent action and do the case again. And
actually, would that include the court in the next action? If that was a concealment, or is that getting too?
Concealment, and I think I'd bring the concealment in. I want to come back to what caused it all, and that was the foreclosure the first time. Say it happened 2 years ago, and that's when everybody went wrong. Mm-hmm. It should have been a trust. It was construed to be under a repudiation, to be a debtor-creditor contract, which was the inducement of the fraudulent concealment and the fraudulent conveyance.
Right. I guess this is something that this is probably something that would be on a lot of people's minds, especially because of the way that the courts are acting now, especially in foreclosure actions. This would be something I think that would be of a major issue, and I think we kind of should kick this around in regards to kind of like what's the best process and procedure that we can proceed in this manner.
Yeah, but I think
but I know what you're saying.
I think they need to know first, they need to know how to prove the trust so the trust can be recognized. Because if you can't get that trust recognized because you don't do it right, there's no case.
Right. And then the first thing is
I see right now, people do not know how to put a case together to prove the trust. So to come in here and start talking about me coming back for fraud and mistake and all this other stuff, if you can't prove the trust, you're not getting anywhere on. You're talking about a third base action when you can't even get onto first.
Get the first base. Okay.
Yeah.
Right. Which is basically is still going to be the expression of the trust through the protective order to get into chamber. Is that correct?
Yes.
Okay. Right. And then from there, once you acknowledge that, of course, you're going to be questioned by the judge to see if is he really competent to administer his trust. And then that's going to be the proving point. And then once that happens, really at that point, you really won once you have proved your competency. Is that correct?
Yeah. Well, if you prove the trust, you've already won.
Right. Now, am I going to third base?
Yeah. Then you could go on to third base. You could ask for whatever you want. Because if equity can't give you the relief that you asked for, then it's going to give you the remedy.
Okay. All right. I'm just trying to structure I'm just trying to see the process, go the A first, then B, then C, then D, and I get a better.
The way I see it, people learn how to get on to first base. They've already got a home run.
Right.
You can walk the rest of the bases, but your hard part is getting on to first base. If you can get past the bleary-eyed watchers of the gatekeepers by getting on first base, you can walk the rest of the way. You can walk
so second base is actually you having the knowledge when you're confronted by the judge to show competency that you can administer your own trust.
Yeah, that's the age of majority.
Right. Okay.
You made the choice from going into the debtor-creditor, the general deposit, the contract by the debtor-creditor. You chose trust. You chose the special instead of the general. It's all about relation. What relation are you doing moment by moment, especially at the time when you sign your name?
Right.
The power to choose from general to special.
Exactly. Now, on anything that we sign, because you say you be careful of everything that you're signing, regardless what it is, whether it's a check, an agreement, anything that's where you basically sign it with an incomplete signature with the 3 dots. Now, doesn't that also illustrate power of attorney?
It comes back to intent, what those 3 dots mean.
Oh, to my intent.
But I grant for.
Oh, okay, so it's my intent, and I don't have to disclose it at the time of doing it, because it was funny, because I did that when I opened up a utility, an account, and I put the 3 dots, and the guy behind the desk surprised me. He goes, "Oh, power of attorney." That's what he said to me, so he recognized it, which really surprised me that he recognized that, working for a utility company.
Uh-huh. There's some out there that know a little bit of something.
Yeah, I was surprised. Okay, well that was that, like right now, just how you're explaining it, it's starting to go click, 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 click. It's starting to click a lot more. Okay, so basically we should really read up section 184 through 189, which is the bingo, and then also up to 191, getting into termination and repudiation.
Yeah, especially 189 through 91.
Okay, so that's the bingo.
Yeah, 189 is bingo. Yep.
Okay, very good. Thank you very much. That was very helpful. Thank you, Chris.
But I think everything that you're getting in the mail, all your bills you're getting presented with, those are all repudiations.
Right.
The trustees are sending you their bills that they should have paid for you, but you never knew it was a trust, and they knew they could get away with it by sending the bill to you and getting you in this debtor-creditor relationship under a government contract and hang you as the trustee because they repudiated. And all you had to do would be to repudiate it back and come back in with the proof of the trust and expressing a breach, but you never knew that.
Oh, so that's even the utility companies are acting like trustees, you're saying?
Yes.
Oh,
yes.
Well, I tell you, it's going to be
your bill.
It's going to be interesting when we really start putting the metal to the fire to see what kind of reaction we're going to get out there.
It's nothing new that we didn't understand, but now we really understand the mechanism of how the court is getting you.
Right. But once again, it's like the relinquishing of power, because they're going to hold on like a cat being taken to a bath. They can't take the rights away because the Declaration of Independence says you can't have any unalienable rights taken away. Right. Unless you voluntarily waive them.
Yes. And suspend the right. Never lose it. You just suspend the right.
But even with a utility company, that would have to absolutely blow their mind. They would know how to act. They would know what to do. They'd have to throw it to their legal department.
The remedy, the relief actually rests with you. You got to know how to bring in a proof of trust. And you got to know how to bring in a claim for breach. Because if you don't express it to be a breach of trust, then there is no claim. Uh-huh. You're stuck with a creditor again.
Right.
So I don't want to come in and at-law and make at-law claims, because that's debtor-creditor.
Well, the thing is, it's not even going to be a court action if you're dealing with like a utility company. Really, it's going to be a private matter, a specially pleaded private matter, correct?
Yeah, go back and withdraw and redeposit as special.
And then name them the trust, and then name them the trustee in the indenture, and then send it to the CEO or the executive director and naming him as trustee.
It's the general, which is the acknowledgement of the debt, or versus the special, which is the acknowledgement of the trust. Which do you want?
Acknowledgement of the trust.
I don't want acknowledgement of the debt. I don't want the general side, debtor side. I don't want the debtor-creditor contract. So I better be acknowledging a trust, expressing and proving a trust. A private trust through NTT.
Right.
I think we just ripped the heart of the courts out today.
I think so, and I think just for, my own mentality is that I got to read it, reread it, read it again, write questions down because I know I'm going to have them. But to really understand it, just covering the surface as we did tonight, yeah, the wheels are already spinning. So it's just a matter of going back so we don't get destroyed for the lack of knowledge.
Yeah, we have defanged the snake. We have taken away the total power over us that we've granted to them. And we have now the knowledge to take it all back. We have the knowledge to stop the suspension of the right.
Yeah, you basically, it's basically, you're just right there is the exposure of everything. Now things are going to start being exposed And now, because they've been hiding behind that for the longest for decades, centuries maybe, who knows?
Yes. But I can't blame them. I'm the one who allowed it to happen, and then I've been blaming them all along. And I really can't.
Well, I'll let somebody else get on, but hey, that was big, Christian. Hey, thank you so much. I think so many of us, and I think I can speak for everybody, we deeply, deeply appreciate the work you have done, and it's been a real godsend to a lot of us, and especially a lot of us that do some very good research. It's just, it's just opened up so many doors. We got a lot of work to do, but you know what? I could see the opening of the paths as we go down them, and as a joint effort, we could all participate, put into it, and get the remedies that we've been looking for the longest time and haven't been able to get.
Yes.
Thank you so much.
I've been seeing dimly, but now I see clearly.
Yes. You're a scholar in a school bus, I always say. I'm kidding. But, no, thank you very much for all the hard work you've put into it. We really deeply appreciate it, because I stay close to all the words that you are speaking. It's just hard to digest unless you actually go back and do your own study, your own absorption of what you've just read and what you've just heard. Myself, I don't have a photogenic memory, so I do have to do everything based on repetition. But once I do understand it and the gears start clicking, it makes you dangerous.
Yeah. Well, go to the law library and pick up Book 54, Corpus Juris Secundum, on the limitations of actions, and just take the tape and listen to it and go through it.
I sure will. All right. Thank you, Chris.
And then when you get a photocopy of that section, those pages and stuff, we can scan them.
Chris just sent me some. He sent me a few of them on acknowledgement. But what I'm actually going to do, because I was given a ton of law books from Florida that I still have with me, and I had some federal ones, but I mean, I got probably over 70 volumes, but they were basically statutes, but I do have some that are, am juris and a few others, but, I'm going to look for some other ones, but I could get some, looking for, some firms that do like to donate and give away some of their old stuff.
Right. And then we also need transcriptionists to transcribe some of these audios and put them down where people could just read them. So if anybody wants to volunteer to do a transcription of maybe tonight's or a section of tonight's even, if we get several people together to transcribe just the sections, make it one whole group effort. So. Right.
I know there was a program. I think I spoke to Eric about this, but it was these guys. I think it was a company from India that actually you could transcribe it at a minimal cost. So of course we could always ask for donations, and I'm sure everybody wouldn't mind doing that. But they do the transcription of a conference call.
Yes, I've heard of that.
That could be a thought too. Why? Because we're all lazy. And I can't type too quick with my two fingers. Okay, but thank you so much. I appreciate all your input.
Okay, Darren, thanks. Bye. Yeah, if you're not in line for the queue to ask any questions, press *6 followed by 1 to get in line and raise your hand. Tammy, you're unmuted.
Hi, CW. Can you hear me?
Yes.
Oh, it was awesome tonight. I got my book out, and it's already all full of notes, but here's where I'm having a brain fart. Okay, I know what repudiation means. That means that the trustee is refusing to accept, the bill and
he's refusing to do the duty as trustee to make the payment. So.
Right. So here's my question. A couple different ways I've seen this worded in here is this verbiage right here, where I'm on page 248. And it's like section 189. It says, if no definite time is fixed for the termination of a trust, here's the verbiage right here I'm confused about. The statute will not begin to run. Them words right there. And in what context does that mean about the statute will not begin to run? Meaning
there's no statute limitations implied until the trust is either terminated or to the trustee repudiates. Okay. And then that starts the clock.
Okay. Now
you got to set up time to bring in an action against the trustee.
Okay.
then doctrine of latches might apply, and doctrine of latches would be at law, really.
Right. Okay. All right, that makes sense, because then it was worded under 191 a little differently. Under notice it said, a trustee's repudiation of the trust and his assertion of an adverse interest will not start the statute of limitations in motion unless and until knowledge or notice thereof is brought home to the beneficiary. So it was worded just a little slightly differently, and that's kind of where I was having the brain fart. Okay, I get it. Yeah, I was like, I wrote wow under something that, yeah.
It's like when they send you a bill in the mail and it gets in your mailbox, you open it up and then you don't do anything with it, or even, if you pay it.
Right, we didn't repudiate.
For yourself.
Right, we didn't repudiate, yeah.
Yeah, yep. But you didn't bring an action against the trustee for a breach of trust. Here you didn't even know it was a trust at all.
Yeah, I'd rather bring one big major action and ignore all them little bills and get her all done in one full swoop, like you say. Go back to that government section is where I'm going to read again. No, it was awesome. What a find. Oh, man. Yeah.
Yeah. I think that there's a section under limitations of actions, a section that's just entitled trust.
Yeah.
180, what was it, 184?
Yeah.
84, section C, trust.
Yeah, I took notes. Yep, I sure did. That's the one that, and the bingo was section 189. But I wrote wow on a bunch of others, not just the bingo one. All of it, the whole thing was wow. Awesome stuff. Yeah, I bet you were as excited finding this as when I was when I got my books. Oh, man.
Probably the biggest find since the discovery of NTT.
Yeah, I would have to agree there. That was my only clarification of this will not start the running and the statute will not begin, and, I'll just...
We always thought, you're being converted or under misconstruement to be the trustee. Now we actually know the mechanism of how. It's a repudiation. And it's happened to you in court, or it's happening to you at your mailbox, or wherever they're getting a presentment of a bill. And that bill is the debtor-creditor contract, but that bill is the, how do they say it under the fraud section? Where's that? The fraudulent conveyance of the property is really a fraudulent concealment. There it is. It's, or the making of the contract induced thereby.
Yeah, induced.
192.
Yeah, inducement. Yeah, exactly.
That inducement is the contract inducement. That is the debtor-creditor contract. That's really a fraudulent concealment.
Oh, for sure, yeah. Yep, it's under fraud mistake, yep. Gotta do a counterclaim for fraud, cross-action, or whatever. Oh, yeah, it just makes you want to go start suing them. Oh, exciting stuff, that's all I gotta say. Repudiate. Somebody, Greenhorn, that doesn't have all this debtor-creditor stuff behind them, could, with simple explanation of this newfound stuff, it wouldn't take much to just, if they're in the right frame of mind and with Yahweh, they could do this verbally in court and have the judge's head in his hands. That's the way I'm seeing it. Of course, only if they're deserving in it. They're not a bad guy type thing, but yeah, unbelievable. Very cool. All right, I'm good. And okay. I commend you, and Lisa too, for all your hard work, and keep up the good work, and
awesome.
Very, very much so. Okay. Keep on. I'll let somebody else get on if they got questions. If I got any more, I'll jump back on. I'm making spaghetti tonight. It's got to slow cook for 6 hours, so I'll be up late.
Okay.
All righty. Thanks again for awesome find. Yeah. Okay. I wish my scanner was working. Yeah. Okay. I'll get doing some transcribing when I get caught up with my bank issue and my pursuing the bank on my issue. So I shall sign out. But again, awesome job. Thanks, CW. Lisa too.
Okay.
Good night. All right. Good night.
Thanks, Tammy. Hello. California, unmuted.
Hi, Christian. It's Jeff. How are you?
Hey. Good.
Yes. Okay. So the statute of limitations then. So that starts basically when the repudiation takes place. It doesn't start until then, is kind of
Correct.
what you were saying.
does not apply to a private trust, an equitable trust.
Right. So that's just on the public side then, basically the statute of limitations, which is under statute.
Yes, yes.
So I was wondering how that was even relating, but I guess that's the public side of it. But are we bringing a cause of action in the public as a breach of trust?
Yes, just like we've been talking before, breach of trust, cause of action.
Yeah. So, and then we actually do identify the new cause of action tonight, which is the fraud, or the I have it in my notes here. Hold on a second. Let's see.
Fraudulent conveyance.
Yeah, fraudulent conveyance. Yeah.
See, that's the if you look under the earlier sections that I didn't really go into a whole lot of, I just touched upon a little bit when you had notice.
Yeah.
When you had knowledge of the
fraudulent
if
conveyance.
we're holding back the knowledge in any way, and that way would be these debtor-creditor contracts, because these contracts are inducing the fraudulent concealment.
Yeah, fraudulent concealment.
So they're actually hiding the truth that is a trust by these debtor-creditor contracts being the concealment of the fact that it's a trust.
Right.
But now that's probably too much truth in court. So
yeah.
I don't know how they're going to bring that in there, so can't let that run on the public side. Now you'll be breaching the trust if you did that.
Well, the fraudulent concealment, bringing that cause of action into a public pleading.
Yeah, you can't let that appear on the public side at all.
That really be letting the cat out of the bag, huh? Yes.
You'd have to have an in-camera hearing on that one, and that would have to be all on the private side.
Yeah. So basically, okay. So the repudiation, as that's related to the prescription, basically the prescription is the repudiation, basically limitation of action. So they're basically repudiating.
Repudiation.
Or it's the result of the repudiation.
Say again?
So the prescription, I guess, is the result of the repudiation.
Only the repudiation.
It's kind of the result of it. Like they're repudiating, so then the prescription starts running.
Well, I guess so. Yeah.
It's just kind of like you didn't repudiate the repudiation, so then the prescription, the limitation of action starts.
Yeah, you
running.
got your right suspended because of that. Yeah.
Yeah. Okay. So that's basically your right to suspend it because the repudiation, your opportunity to repudiate, and you didn't. Okay.
We really shouldn't be claiming that everything you do in that realm is all fraud. No, it's all fraudulent concealment.
Right. All of it, essentially. Well, once you know the truth. And then you have to have proof of the trust, like you said, before you could even go to the fraudulent concealment and conveyance. Because if you can't prove a trust, you can't prove there's any fraudulent concealment.
If we were over there trying to enforce a fraud, who are we going to try and enforce a fraud against? Because they don't live over there. They're still in the private. Right. There's nobody in the public except us. So we're going to bring charges against ourselves? I don't think so. Don't go at law and bring any charges against yourself.
Not wise. So they're in the private because I'm a little bit confused about that exactly, how they're still in the Republic in private.
They're still in the Republic, yes. They never left the Republic.
They're just repudiating, the trustees repudiating. So they're really acting in the public, but they're just actors from the private side and acting in the public.
Well, it's like a
puppet show.
Yeah, you're charging a red cape being the bull, the dumb bull, and your problem is that the bullfighter who's living in the Republic in the private, you're being duped to follow the red cape and go into the public. Now we got to learn that's not the cape. Stop chasing the public. Get out of the public. Get back in there. Your beef was with the bullfighter in the private. Can't win by going and chasing that red cape and going at the public side.
Right.
And you're being led to charge that and go into the public, and you now live in the public.
Right.
If we do a withdrawal and a redeposit, put ourselves back in the private, and then don't go back and commingle and try to get an at-law remedy, stick in equity and go for a release in equity, and don't ever cross back over.
Yeah.
I mean, some of this stuff is like a mind twist. But you got to bend your mind. You can't bend the spoon.
Right. Yeah. It's really just going back to you can't have your unalienable rights taken away. They can be suspended, but it's up to you.
That's the bait and the trap. I think it's in India or someplace where they trap monkeys by putting a milk bottle with a nut inside there, and they like those nuts. And they get their hand in there and they grab that nut. When they make a fist, they can't get their hand out of the bottle. And the bottle is fastened to a stake in the ground.
Oh, yeah.
Then they've caught the monkey, and they just walk right up there. The monkey won't give rid of the nut, and they can't get his hand out of the bottle, so then they grab the monkey.
Yeah.
All that monkey had to do was let go of the nut, get his hand out of there, and run away. But yet he won't let go of the nut. There's these people out there that are acting like nuts. They won't stop going into the at-law side for a remedy, a relief.
Yeah.
I mean, a remedy. They want to go in, they want to get that remedy at the at-law side. That is the benefit the benefit that's in the trap. That's the nut. And when you grab the benefit, the at-law side remedy, you get stuck in the trap. Don't go in there.
Yeah.
Get your relief in equity.
Yeah.
Stay out of the at-law side.
Can you just say, I waive the benefit of that law? I mean, you know.
That doesn't mean that you just don't go to court altogether. No. You got to go to court to claim your equitable right. Got to do that, as far as I know, so far.
So we want to claim the equitable right and waive the benefit of that law proceedings.
Yes. Yes.
That's essentially what we're doing. Waive the benefit of.
Pursue the equitable relief. Go after the breach of the right and go after the performance. And when you win because of the breach of performance, because the trustee is assumed to be guilty already, you've already won. The only thing you got to do is prove a trust. If you prove a trust, you're already won.
So
you can't do the relief that you asked for the performance. They must go into the at-law and give you something that's some kind of remedy to make you whole.
So now this is kind of reshaping
all that garbage of pleading in court and arguing again.
This is kind of reshaping the view of the trustee a little bit again over this concept, because now it's whoever's repudiating is obviously the trustee.
Yes,
I mean, that's
whoever's handing you the bill is the repudiator.
So it's both the judge and the district attorney in a court case potentially, because they both are basically handing you the adverse claim. They're both acknowledging the adverse claim and asking you why you haven't paid it essentially. So it would definitely be the judge. The judge holds the instrument most of the time, at least in his file.
I would definitely the prosecutor. Let's put it that way.
Yeah, for sure.
Now, the judge may be complicit on the facts, also participating in the whole thing, but the way it's set up, I might need him to be independent and at arm's length to give a judgment.
Right, or you're gonna have to appeal it. I think
if I probably make a trustee. He's gonna have to get off the case. And then I got another problem. I got another judge.
Yeah.
What are you gonna do? Make him trustee? Then he's got to get off the case.
Right.
So I never can get a judge to give me a relief.
Well, or the way I started looking at it is, well, the original action with you assign that original judge, and then you pull it from there and have another judge on it. You know, I don't know if that makes sense.
If I had to, maybe.
Because it seems like the judge is going to be, I mean, they are repudiating the claim, and, you know, most of the time.
I think if we go in with a well-made out pleading with support of a memorandum in law showing the equity and the trust law, that they know that we know what the game is.
Right.
Now that holds their feet to the fire and says, you know, if you don't judge this appropriately, according to the facts entered into evidence and the conclusions based on the law that I gave you, then this is going to get bounced back to you on an appeal.
Yeah. So we got to really work on that memorandum of law, points of authority, basically, because that's going to be where we're going to bounce it back to. They're going to have to judge it upon that based on the facts that we present, besides the facts we present, and the jurisprudence to give them the guidance, essentially, to judge on our side.
Right.
So our intent and our purpose, once again, using the law, the purpose would be probably the law, and our intent would be our acts and records. So got to have all that in every step of it, it seems like. Because we're looking to get this resolved. We're really looking for the results. We're really not looking for endless amounts of appeals. We're really looking for the relief that we're in there for. And I think if we give them any wiggle room, they're going to wiggle right away. And so we really got to do our homework. Every aspect of it is, you know, being able to.
So far now, yeah. It depends upon us having the knowledge and what to do.
Right. And then our SOIs with our NOI to substantiate that as well, which has to be in a form, like I think it's a declaration essentially, or a, you know, like you say, affidavit essentially, to be able to substantiate that, or they won't even recognize that.
Well, even with well-constructed pleading, according to how Marshall described in that book there on forms and pleading.
Yeah.
Inequity.
Yeah. Has to be properly stated.
Because there was this one party that was in the chat there that said something about, of course this was secondhand knowledge, but they were saying that the fellow had lost in court. The judge told him that your private trust has no standing in at law or has no legal or at law standing. And basically what they told him was that 12B6, so your state of claim upon which relief could be granted, because probably his pleading didn't contain the elements necessary to support the claim for trust.
Right. So at that point you would request a grant to amend the pleading.
Yeah, you better.
Request time to grant to amend pleading if there was a defect.
Yeah. And the judge was kindly telling you that you didn't have a case, didn't have a claim. Yeah. That wasn't his fault. It was your fault.
Yeah.
Darn judge, he ran right over me. No, he didn't. He just told you were dumb. Got a frivolous thing in there. Go back and do it again.
And then, so there was another thing I think you said tonight. It basically related to repudiation. Acknowledgement of the debt, you're saying, is basically on debtor and creditor side, and then we're just really acknowledgement of the trust, because really the debt is just more of the same fiction that's going on.
Acknowledgement of the debt is the debt's on the debtor-creditor side, and I don't want to acknowledge the debt. I should be acknowledging the trust, which is on the equity.
Yeah. Or by acknowledgement. And
tonight, we don't want acknowledgement of the debt, the trust, which is
repudiation.
Yeah.
So it's
both. Action to breach of trust.
So basically, we repeat expressing the trust. So basically, to respond to the repudiation, well, you're going to disclaim the appointment of.
I was in court and the judge, plaintiff handed me the complaint. They're repudiating. Then I'm going to say that there was give them notice in open court. This is a breach of trust. Trustees made the trustee notice in open court. Better be able to battle that prove that there is a trust and get them in that breach of trust because
we asked to see the original charging instrument or the original matrix, and then in open court when you're reviewing it, you're like, this is a breach of trust.
That's fraudulent concealment. You're not making a claim for that either.
Right.
They're hitting you with the debtor contract, which is the contract for the fraudulent concealment. But you're not making a claim for that either. And you probably could make that claim because that's reflecting back to the private trust that's in existence. You can't claim that, not in the public side.
Right. So I'm trying to envision someone being in court potentially, and I think we've gone through a lot of morphs here, and we're just kind of morphing our perspective. We were talking where the fact that there's a breach of trust. That's actually
that's a criminal case dependent upon versus a.
But I mean, it's all fraudulent concealment, and it all is a breach of trust.
Yeah. Please. As far as I know, nothing has really changed. You may still have to colorably change your and colorably claim that the side has been paid. The change of plea would be the criminal side. The payment has been made or a breach of trust, which should have paid the trust or should have been paid the civil side through the trust. Didn't happen. So, but you got to come in with two colorable things.
I wonder if you could just do that strictly through the pleading.
Well, this thing that's too hard to bring in the public.
You can't bring it in the public at all.
Huh. You still have to bring the nothing's really changed. We just now understand what has. We understand the mechanism.
I was just saying, I found a bunch of interesting stuff, and I went and read Repudiation, which was not really a lot of together. But I found some stuff like deliberative process, which I relate to this. Process privilege to withhold documents relating to policy may encourage open and those are government policy.
Yeah, fraudulent concealment.
Yeah, so that's deliberative process privilege, as they call it. The people. It's up to the people to call it out, right?
Yeah, we don't.
Privilege, which is under information. made with reference to a judicial proceeding. So basically, the stuff is kind of a judicial privilege in a sense, or private information.
Well, nobody really wanted to live in the public side. They would start complaining and changing the law, but nobody does. So I guess everything's all right over there.
Yeah.
I guess everybody's okay with the mortgage foreclosure industry and everything collapsing around your ears and everything.
Yeah.
Nobody's doing what really counts, which is seeking the truth.
Yeah, here's one more term, special privilege, and derogation of the common right. So that's essentially what we're doing with, I think, is kind of this, we have actually special privilege.
Yeah, why did you do that? Why did I agree with that?
Right, yeah, I guess that's more like it. And why we agree with our rights being suspended. I guess that's really what we have to come down to,
Well, one thing, people don't read this stuff.
Yeah, they don't know how to correct it.
I don't want to listen to all that stuff. I got more better stuff to do. Watch TV, take Johnny to the soccer game. I got this to do, that to do. Meantime, your whole world's collapsing around your ears.
Yeah. Yeah. Been kind of like studying a lot of this, and it's really that the fine line of just getting out of the public and getting into the private. It's really, it's hard to inform them in the public trust without abandoning the position in the private trust. I mean, we really, that's the challenge, right? Because in the public trust, if you expose your position, or you're just,
we need to start looking at it that we are the only ones that are in the public and they are in the private.
Right. And we just have to get to the private and abandon the position in the public.
And we have to abandon the public position. Go back and start reclaiming your stuff in equity. Don't don't live in that at-law side any longer in the public. You want your republic back, your America? You want your common law back? Stop living in the public.
Yeah.
Stop going into court and choosing the at-law remedy. Don't go there.
And this is from the Bible, confusion of God and confusion is intermediate for pieces of personal property so that the property rights in each can no longer be distinguished. There's a separation of the formerly
Yeah, that's also conversion.
Yeah, or merger.
Well, yeah, get it back.
I'm saying there's no specific identification or separation of formerly as possible. So, yeah, confusion of that. I also looked at conflict of interest, which has a different interest in a real or seemingly incompatibility between one interest and one public fiduciary duty.
Right.
Yeah, it's there. It's just us figuring out how to make our records and express it and standing up, not traversing. Confusion, though. That's what they've done. They've made it confusing. So we are basically merging our rights, our private rights with our public rights.
That's what it is. Confusing.
Yeah. Okay. Well, thank you for my...
Unless you...
Yeah. Well, that's what you're doing. You're decoding it. And the way you decode it, simplify it. Go back to equity. That's the only way to really decode is read that.
Equity, I don't have to worry about all the codes and statutes.
Exactly. And the confusion back to truth, which is we are the equity. Only equity there is.
Yes. I only got 12 maxims to worry about, and that's 63 plus statutes and code laws.
Yeah, saying that. Okay, well, appreciate the work. It's great. I've been really just looking through CJS, and that's really seems like the most powerful tool we have. Most focused.
Yes.
Where the nuggets are. Okay. Off the line. Have a nice day. Say hi to Lisa. Thank you.
All right, thanks, Jeff.
Goodbye.
Want to ask a question? Press *6 to raise your hand, followed by 1. State your name and where you're from. *6 followed by 1. 954, you're unmuted. 954.
Hello?
Oh?
Yes, I just have one question. I've been listening for a while. It's very, very interesting. Our filing our trust, and my question is, where do book or set of instructions so that we can... Hello?
Yes, we got some background.
Oh, okay. I just wanted to get the four witnesses for the UC and that's been processed, but we had we don't send the documents. and what type of instructions or letters that we need to include with those documents. Can you expand on that?
Well, if you filed the 4 witnesses, being the UCCs and the county, then what indenture that you created sent to the trustee with the res, because those public witnesses, those are the notices of what you've already done in the past.
Okay, well, am I on the right track on what I'm doing?
Well, let's go back to what you actually sent. What is it that you're filing on the UCCs and the county recorded 4 witnesses?
Foreclosure of
or foreclosure.
property.
So you took the foreclosure documents and you took the foreclosure documents and did what with them?
Well, that's the standstill. Since we found the other, I assume that we would have to attach those and forward them to, and we at a standstill, just have the other attachments along with those foreclosure documents.
Like for the horse, that you're doing the filing of the UCCs and the counties and giving notice of something that you didn't. If you didn't take a foreclosure document, say, and turn them into trust res and send them to the trustee, then there is no reason to be filing anything on the UCC and the county.
Okay, so I needed to take the foreclosure documents and form them into a trust, you said?
Yes.
Okay, I didn't do that. That's why I was calling to get some guidance here. Is there a book or something that I can get to kind of give me a little better guidance on this?
The past audio tapes, the downloads from 11/7 of 2009 and forward until tonight's call. I know there's a lot of audios. Certain ones are better than others for specific things. Are you on the NTT welcome group? Right?
Yes, my son got me on that. Yes.
Okay. If you could get into that group there and maybe ask some basic questions, some people in there could help you out, and there might be some trust ambassadors that will come on and pass on some of the knowledge and help you out that way. Because it sounds like you've got a wrong concept of what you need to do first, and you've gone ahead and completed step 2 without finishing step 1.
Okay. All right, well, that's why I called. Okay, let me see if I can get myself back on the right track, and I thank you very much, and for your information.
What you should have done is taken the documents and turned them into trust res and mailed them to the trustee and formed a trust. What you would have done is
take a foreclosure document and turn them into a trust, right?
Yeah.
And then forward to the
trustee. And when you made a full deposit to the trustee of the documents that you turned into a trust, then at that time the trust was formed. Then sometime after that, then you would want to do a UCC1 claiming what you did and a county recorder.
Right.
And then I would have done a UCC3,
okay,
which would have been the withdrawal, transfer back to me, and a county recorder on that. Okay. Then I would do a second UCC3. After I transferred it to me with the first one, I would transfer it back to them, the new trustee, on a second UCC3 and another county recorder.
Okay.
Now that's just notices of what I did in the past.
Okay. And where would that lead me?
Okay, that leaves you with trust formation. Now in the special deposit instructions that I sent to the trustee, that would be the indenture. And there's where I'd have intent, purpose, party, specific trust res, and a method of formation. Now what you got to do is you got to go back to the audios when we're talking about on Gilbert's Law Summary back in probably December when we started going over that whole book from front page to back. Okay. You need to go on those audio tapes and go in there and find out how the trust is formed according to Gilbert's Law Summaries on trust. And that's usually on the Wednesday night call that we did on TalkShoe.
All right, because I thought I was doing something wrong. I wasn't sure,
Yeah,
but I better stop before I really screw up.
Yeah, because what you need to do, you need to get a starting point, and you're not quite at start in the right place, I think. And if somebody could help you out, maybe according to the dates, because I don't know what the dates are myself. You need to get into the Gilbert's Law Summary when we first started discussing those on the audio.
Okay.
To tell you how to form a trust. You got to have intent parties, purpose, and specific trust res. That's like on page 18. Then page 87 is where the method of formation is, and that's by delivery, by mail delivery.
Okay, well, if I can't find that, I mean, where is there a store? Can I get it from Barnes and Noble or something?
Yeah, Barnes and Noble, you can order it at Gilbert's Trust. Okay. But I'd go on the Welcome NTT group and ask somebody if they know the dates of the audios for the beginning of when we went over the Gilbert's Law Summaries on trust.
Okay.
And ask maybe some of the basic steps on how to form a trust, because that's what you need before you start doing the UCC notices.
Okay. All right, Mr. Christian, I really appreciate that. It's been very helpful. And I'll follow up on this. I'll make sure I don't get myself in any trouble here.
Right, because it sounds like you haven't formed a trust yet, and you're giving notice to everybody that you have.
Oh, okay. All right, sir. Well, thank you very much. And have a good evening.
All right. Somebody Skyped back and said 11/11/2009 is where it starts.
11/11?
Yes, 11/11/2009, the Wednesday call.
Okay. Thank you very much.
There's probably others. Wednesday calls is usually the one. Okay, anybody have a question? Press *6 followed by a 1. Michael, you're unmuted.
Hey, CW, how you doing?
All right.
I'm going to tell you a little story that what you read tonight really does work. At the beginning of last year in November, when I really started listening to you, my wife had major surgery. And we owed a huge hospital bill for the doctors and everything else. And at that point in time, we got the bills, and I basically said I was power of attorney. And I'm not telling anybody to do this, okay? But I'm just saying that the repudiation does work. Because at that point in time, I sent back the letter back to the CEO of the hospital saying that he's the trustee of the account, and I gave him the account number and said, I'm instructing you to pay all bills. And of course, he sent back a letter about 3 weeks later from his secretary, and she's saying that we didn't understand what you're saying. You have to pay the bill. Then I sent another letter back to the CEO saying that he's in breach of trust. So basically what I did, I repudiated it right then and there that we didn't know the bill and forced them to pay the bill. And guess what? It was paid.
Yeah.
And I didn't even know that when I was doing that.
Yeah.
And I didn't even express the trust as what we're doing here as a proof. But because I came at him at that angle and showed him that I had power of attorney and everything else, he paid the trust. He paid all the doctors, and it was a hefty bill.
Mm-hmm. Wow.
So we got a bingo. You got a bingo. We all got a bingo here. We have to put the verbiage out there right, and which it seemed very basic and very simple to me. Just expressing the trust like you said, and then just turn around and just say, we repudiate, your accession that we owe the bill. You are the trustee. You are now ordered to pay the bill. If not, then you're in breach of trust, and we'll bring it back into court on those grounds. And in so many words.
Yep.
So, thanks again, Dad. You did great work again.
You're welcome.
Thank you very much. Bye-bye.
802, you're unmuted.
Hi there. This is Timothy in Vermont, and I've got a court date on Tuesday, a hearing, and I just talked with a friend, and he was telling me about NTT today, and I listened to you probably back in May, and so I'm putting together this process on how to go into this hearing. I wasn't going to go in at all because I'd already filed a motion to dismiss via reservation of all rights, UCC 1-308, and also an abatement. This is for a traffic violation, and whereby I was claiming my rights to travel and my diplomatic immunity, and they threw me in jail, and I was released on bail. So for contempt. And then when they brought me into the court, I wouldn't go before the bar, and they picked me up and threw me in before the bar, whereby I reserved my rights. And so basically what you were saying, he's saying that I need professional help because they're in La La Land and I'm acting in truth. So I guess I would like to ask to establish the trust. What would be the best way if when I go in, I say I am the Timothy Edgar and grantor beneficiary, and then I would say I'd like to withdraw the funds and redeposit them in the equity side. Hello?
Well, I think I would come in and say that for sure that I was so-and-so name and grantor in fact.
Grantor in fact.
Yeah.
Uh-huh.
And I would probably be saying that this hearing is contrary to equity and trust is a special matter, and there exists no adequate remedy at law, and I invoke the private side of equity for relief. And then just like Michael was saying there that I would basically tell him I repudiate the offer. You fellows are really trustees, and I order you to pay the bill, or you're going to be in breach of trust.
Right. That makes sense because there's no way, at no time during this whole process did I sign anything and give my consent to any of the process.
Well, they really don't need your consent. They've already got your consent by operation of law. But what you need to do is you need to express a trust. Now, you could express a trust that way. Now, the judge may say, I don't see a trust, but then that's the garage door opening big enough to drive a Mack truck through for you to prove the trust then. So
okay,
now you got to have the information ready to prove the trust, or else do a postponement and set a hearing date for sometime down in the future to have an evidentiary hearing to prove the trust.
And to prove the trust, I'd have to go through the UCC thing you were just talking about. I mean, I'm agreeing.
Yes, because those are the notices on the public side or the SOIs that you need to support the claim, say that I have a trust.
All right. So I need to get information on how to produce the SOIs, whatever that means.
A statement of interest.
Statement of interest. Okay. Statement of interest.
Those are the notices. Those are the colorable notices, the UCC 1s and the 3s, and the county recorders. So
all right.
They're the colorable ones.
All right, my friend might be able to give me information on those. And so a pleading to reschedule a hearing so that I can get these.
Yeah, that's if the judge says I don't see a trust. Now you got to prove a trust.
Okay.
Now, it might not go that way, but if it did, then you'd have to be able to prove a trust. It could just all be closed down right then.
Yeah, but if it isn't, my pleading would be to have a later hearing date whereby I come back and prove the trust.
Yes.
All right.
And then those colorable SOIs are pointing to the real ones that are on the private side, and the real one would be your green card of the signature that you sent the trust res to the trustee, and you got his signature on this green card.
I see. Yep. Registered mail. Well, I've been sending a lot of registered mail to the, whether it be a letter rogatory,
and what you would have sent him privately would be the indenture, which would be the instructions for the special deposit, which would be the formation of the trust. And in that special deposit instructions would be you'd have intent, purpose, parties, specific trust res identified, and then you would have the fifth one being the method of formation of the trust, which would be the delivery or the mail delivery, and the proof of that being the green card. Now you got all 5 elements necessary that the law will recognize to be a trust. And you can bring this in chambers to prove that you got a trust.
I see. That makes sense. And obviously I don't have the time to do that, considering I just found out or rediscovered this tonight, before Tuesday, but I can at least vocally speak it and then go ahead with the preparations if I have to reschedule a hearing to prove it.
Well, I'm going to claim that I'm grantor in fact.
Grantor in fact.
I know who the parties are. I know who the beneficiary is. I know who the trustee is. And I'm going to tell them in open court, you, so-and-so, are the trustee. And I'll order you, whoever you appoint.
Yep.
I would suggest doing to the prosecutor or whoever is going to be there for the other side, plaintiff.
So not the judge. You do the prosecutor as being the trustee.
Yeah.
Because they're the ones coming forth with the charge. No one. I asked in the open court, does anybody have a claim against me? And everybody just looked at me as if I was green.
Now that's too debtor-creditor stuff. We do just purely trust, and we don't do the creditor stuff.
Yeah. But
we're going to say that I'm grantor. In fact, I know who the parties are because I'm grantor. If I'm the grantor, I know who it was. I know who the trustee is, who the beneficiaries are. And I'm going to tell them, did you not receive trust res?
And trust res is, how do you prove trust res with the prosecutor?
Take
his
bill.
Go ahead.
Take bill and turn that into an equitable asset by signing it and dating it.
On both sides?
Yes, on both sides, yeah, front and back.
Front and back, because all the paperwork they've given me, I sent back, returned for cause without commercial dishonor.
Well, then you need to get some certified copies and do it again.
Yep.
Because what you want to do, instead of the except for value overlay, you put your signature on there, and you want to put the trust account, the strawman name, followed by the account numbers without the dashes. That is the trust account. You want to put your signature below that, and you want to put the date on that at least. And then you want to put on there also, to start out, you want to put in there 4 special deposits.
Right. Yep.
Then you want to endorse it on the back, say without recourse, and put your signature on there, and then I want to sign by grantor in the front, and I want to sign by trustee on the back.
Now, why is you signing as trustee on the back?
Trustee is the one who makes the payment. Or let's see.
So I'm making the payment, and
excuse me, I'll take that back. You're forming the trust there the first time. I'll take that back. You want to sign by grantor. You're forming the trust. And now you're delivering trust to the trustee. So I want to sign by grantor on this.
Sign by grantor on the front and sign by grantor on the back.
Yeah, right.
All right. So I need to get
just by notary presentment and by green card, registered mail. So I got proof that I sent trust res, the special deposit, to the trustee. Then once I got that trust delivered into his hands of the trustee, now I got a trust.
Now there's no bill, but there's I'm sure there's just the notice of hearing, and in and of itself, I could make that into a special deposit.
Where was the charging instrument?
That's right. It's on the charging, right?
The ticket or the indictment or the whatever part.
Right. It could be the original ticket of the police. Well, there's 2 of them actually, but okay.
Once you deliver the trust res to the trustee, you got a trust. Then I do the UCC1 to claim it in the county, that it was claiming it was mine. Then I do a UCC3 as a transfer notice that I've already transferred. The 3 is not a actual transfer. It's just a notice of a transfer, of a passive sense. The actual transfer was done in the past. And I'm just going to create a present notice of what was done in the past.
I see.
And a county recorder. Now I've got 4 pieces of evidence, 2 pieces that proves that it was mine to do something with, so that I could transfer it with the UCC3 in the county to prove that it was done.
Yep.
I attached copies, certified copies of the 3s in the county as colorable SOIs to prove that I had a trust. And then I saved the others, the actual originals, the green cards, and the actual delivery from to save that for the private side in chambers to produce the evidence in an in-camera hearing.
Right, in the private side. Okay, well, this gives me something to work from, and obviously I got to get in there on Tuesday and get a certified copy. But might be good to make a motion, because the court assigned me a public defender, because they said he needs professional help, because he's bringing the truth, right, as you were saying. And I need to. So, what would be the best way to bring a motion such that I'm not going to be represented by an attorney, because I haven't given my consent at all to him, and 2, that I'm the first to speak. Hello?
Come back in with as a counterclaim. That'll put you on top.
Okay, counterclaim. Counterclaim to represent myself.
Yeah, if you have more time, you could get them in a breach of trust because you gave them so much time to pay the bill and they didn't pay the bill. You could get them in a breach of trust, and your breach of trust could be the counterclaim. And you could come in with the counterclaim being equitable, and it's on the top, so it gets heard first before the claim, before plaintiff's claim. It must be adjudicated first, but I don't know if you got enough time for that. But
no, it's Tuesday. Well, I'll think about it.
Ask for a postponement.
Okay.
Ask for an extension of time. Or let's see, this would be a continuance of a hearing.
And for what reason? I'm not prepared.
Yeah, it's a good question. You might have to do that in open court.
Yep. And if I do it in open court, not bring up the trust issues there.
I think I'd bring up trust issues.
I would bring up the trust
You
issues.
say, my name is so-and-so, I'm grantor in fact, and this hearing is contrary to equity. Trust is a special matter, as there exists no adequate remedy at law, and I invoke the private side of equity for relief and motion for continuance.
God, you said that really good. Contrary to law.
Is
Number
so-and-so, or in fact.
Grantor in fact. Got that part.
Number 2, this hearing is contrary to equity.
This hearing is contrary to equity.
Number 3, trust is a special matter.
Trust is a special matter. Yep.
4, as there exists no adequate remedy at law. That's important.
As there exists no adequate remedy at law.
No adequate remedy at law. That's a direct quote out of Corpus Juris Secundum, Book on Equity.
Yep.
And then 5, I invoke the private side of equity for relief.
I invoke the private side for remedy.
I invoke the private side of equity for relief.
Of equity. Okay. Thank you very much.
And one would be motion for continuance. What dates are open on the calendar, Your Honor? Or I would go for the kill right there. I'd go right directly for the jugular vein. I'd ask for the trustee to make the payment. I would repudiate the offer for repudiation.
Ask trustee to make payment. And what was the second
part? I
order.
order the trustee to make the payment.
Yep. And what was the second part after I say the trustee to make payment? Order the trustee.
Repudiate repudiation. And order the trustee. I repudiate the repudiation and order the trustee to make payment, or he will be in breach of trust.
Breach of trust. All right.
And I would give him, I'll give you 3 days.
3 days to make payment. Sounds good. I'm going to go write this all again 5 times and and go get Corpus Juris Secundum. All right. Thanks a lot.
All right. Good luck.
Thanks.
Lord be with
you. Yes. All right. Bye. How do I get off?
Oh, she'll boot you out. Is it? Okay, this is getting kind of late, so we'll close it down. I think we'll end it there. But get the recording on this show and pass it on to everybody. And we'll probably be discussing this on the next show to follow on Monday. So we'll see you all on Monday. Thanks for listening to me tonight. So this bingo, hope you pass on. So see you Monday. Night all.